In this video, we will begin our examination of UCC Article 2 in earnest by starting at the very beginning and asking, what does Article 2 cover? Specifically, what kinds of contracts, what kinds of transactions are governed by UCC Article 2? More simply stated, what is the scope of Article 2? This will be our roadmap for answering this foundational question. And in this video, we will cover the very first of these topics. So let's start at the beginning. What are transactions in goods anyway? As we have already said, each article of the UCC other than Article 1 applies to a specific type of commercial transaction. So it is important to understand the scope of each article, and in particular for us, the scope of UCC Article 2. Now, if we want to learn the scope of Article 2, how should we go about determining this? What I am about to say is something you will hear me repeat throughout this course because it is important and it bears repeating. But let me emphasize it at the very outset. When dealing with any statute, including the UCC, the first answer is always to start with the statute. Indeed, one of the main takeaways from this module is that the UCC's provisions are complex and interconnected. One provision will reference another. What one provision says will have implications for another provision. As a student or as a lawyer, mastery of any statutory area, like commercial law, requires that you fully engage with the statute. The scope of Article 2 is helpfully defined for us in Section 102 of Article 2, which reads that unless the context otherwise requires, and except as provided in subsection 3, this article applies to transactions in goods. So, now we know that the scope of Article 2 covers transactions in goods. But we can't stop there. Indeed, we've only begun. The next question we must answer is, what does this provision mean? To answer that question, we must figure out two things. What are transactions and what are goods? Let's start first with transactions. What does transactions mean in this context? When any statute, like the UCC, uses a term and you want to determine what that term means, your first step should always be to start with the statute. Especially when dealing with the UCC, always check to see if that term is statutorily defined somewhere. Indeed, the UCC includes various definitions provisions. Article 1 defines various terms in Section 201. And remember, because Article 1 is applicable to all of the other articles of the UCC, the definitions set forth in Section 201 of Article 1 also apply to Article 2. Likewise, Article 2 also defines terms in various sections, including Section 104, 105, and 106 of Article 2. But unlike Article 1's definitions, the terms that are defined in Article 2 are applicable only to Article 2. So let's come back to the term transactions. What does this term mean? Note first that Section 102 of Article 2 says that Article 2 applies not to sales, but to transactions. It uses the word transactions. Unfortunately, transactions is not defined anywhere in the UCC. So, to determine the meaning of this term, we might rely on the ordinary dictionary definition found outside of the statute. And looking to a dictionary definition of transactions, it would certainly include a sale of goods, but what about other types of transactions? For example, a lease of goods. Transactions could also include leases, but take another look at Section 102. It begins with the language unless the context otherwise requires. We know that the UCC includes another article, Article 2A, that specifically governs leases of goods. So the context here suggests that transactions covered by Article 2 excludes the leases of goods. Okay, so we know leases are not covered by Article 2, but what about other types of transactions? Transactions could include all sorts of other business arrangements or economic exchanges. For example, what about a transaction in which a buyer borrows money to purchase goods and in connection with that loan gives the lender a security interest in the goods purchased, essentially putting up the goods as collateral for that loan? Security interests like these are covered by a separate article of the UCC, Article 9. So, we might point to the same context otherwise requires language to conclude that a grant of a security interest is not included in the transactions covered by Article 2. But Section 102 also makes this point more explicitly in subsection 3, which provides that this article does not apply to any transactions that operates only to create a security interest. So, for now at least, we can safely conclude that transactions in goods does not include leases of goods or a grant of a security interest in goods, but it must almost certainly include a sale of goods. But now we need to determine, what do we mean by a sale? Again, let's start with the statute to answer this question. Article 2 does define sale for us. How would we know this? Well, after each provision of the UCC, there are typically two other pieces of important information that you should also look at closely. First are the official comments. The official comments to each provision were drafted by the UCC's drafters and provide an explanation of what the drafters intended the statutory text to mean. Note, the official comments are not a part of the statutory text itself, so the official comments are not binding law in any jurisdiction. Even so, the official comments have proven hugely influential on the courts. They are frequently cited in judicial opinions. Consequently, the official comments are critical in helping you understand the statutory text. Specifically, how the statutory text should be interpreted and how it fits into the larger statutory scheme of the UCC. The other important piece of information after each statutory provision is a list of cross-references to other provisions of the UCC. These cross-references help you identify where interrelated provisions of the UCC are located within the code. And if you look closely at the end of Section 102, you'll see a cross-reference for the definition of sale found under Section 106 of Article 2. Sale is defined in Section 106, subsection 1, to mean the passing of title from the seller to the buyer for a price, pursuant to Section 401 of Article 2. But note that the previous sentence also defines a contract for sale to include both a present sale, that is what would be considered a mere exchange under the common law and not necessarily a contractual relationship, as well as a promise to sell at some future time, so an exchange of promises, what would be considered a classic bilateral contract under the common law. And presumably, although the statute does not say this explicitly, some combination of a present and or a future sale would also constitute a contract for sale. So, now we have a fuller sense of what the statute means by transactions. It means sales and not leases or the grant of security interests, and a contract for sale includes both a present exchange of goods for consideration and a promise to engage in a future exchange of goods for consideration. But what about goods? What does goods mean? Section 105, subsection 1, gives us a definition for goods. And note that Section 102 does not explicitly cross-reference Section 105. So, how are we supposed to know to look at 105 to find this definition? It requires that you develop familiarity with the statute. And to develop that familiarity with the statute, you must either work closely with the statute or take a course like this one that will force you to take a close look at the statutory text. The definition provided in 105 says that goods means all things, including specially manufactured goods, which are movable at the time of identification to the contract for sale. Note that this definition itself raises additional interpretive questions. For example, what do we mean by identification, and when does identification occur? Because something is only considered a goods if it is movable at the time of identification. Identification is discussed in Section 501 of Article 2. Note again that Section 105 does not explicitly cross-reference 501. You just need to develop the familiarity with Article 2 to know that it's there. 501 says that identification is when the buyer gets a special property and insurable interest in the goods. So when does that happen? The time of identification occurs as agreed by the parties. But in the absence of the parties' agreement, which is the case for the vast majority of Article 2 transactions, 501 gives us a set of default rules as to when identification occurs. It says that as to existing goods, that is, goods that are already in existence when the contract is made, identification occurs when the contract is made. And as to future goods, that is, goods that have yet to be produced or procured at the time the contract for those goods is made, identification occurs when the seller has shipped, marked, or otherwise designated those goods as the goods subject to her contract with the buyer. So, Section 102 together with 105 tells us what are considered goods. Anything that is movable at the time of identification. The car that you might drive, the laptop you are using now, the phone that you check when you get bored with class, the clothes on your back, the coffee beans that you ground up this morning to survive the day, even the produce you might buy at the grocery store to prepare your dinner tonight. So long as it is movable at the time of identification, it is goods subject to Article 2. So to summarize, after looking at 4 different provisions of Article 2, sections 102, 105, 106, and 501, we now have some sense of the scope of Article 2. It governs any sale of goods. Moreover, we now know what both terms sale and goods mean and what is included in Article 2's coverage. But we're not done yet. In the next video, we will see that some things we might think are goods are in fact excluded from the scope of UCC Article 2.